Good morning, good afternoon or good evening. Welcome to the Law Vlog, episode 14. So in today's vlog we're going to discuss a certain part of litigation. We have a person in the case, it's a road traffic accident. I'll go through the details of the case when I get into the office, and the case is currently for hearing in the circuit court. But over the course of the last number of months, our client's injuries haven't improved, and in fact they've got worse. So we're going to transfer that case to the circuit court, to the High Court, and make an application by way of motion with a barrister to have the case transferred from the circuit to the High Court. So the facts of the initial case is our client plaintiff was in a road traffic accident. She was rear-ended by someone driving another car. She initially suffered, the accident was about 3 years ago, lower back pain, neck, and ongoing issues with her ability to walk or even and then work. Our client was actually the injuries have put her out of work for some time, and due to the ongoing severity of the injuries and her not being able to recover and not being able to work, her loss of earnings have now substantially increased, which have now come out of the circuit court jurisdiction, or that is the jurisdiction of the judge. If the case was heard in the circuit court and we were successful, could allow us to recover. So our application today is to ask the judge by way of motion to transfer the court into the first part of the process to have the case transferred to the High Court is we firstly ask the other side, the solicitors for the defendant, whether they will confirm or agree to the case to continue to be heard in the circuit court, but that the judge may have unlimited jurisdiction. That means that if it goes in front of the judge, he or she it's not limited by the jurisdiction of the circuit court, and if they feel if we're successful, they can make an award of compensation greater than what they would generally have given if it was normal circuit court rules. Jurisdiction for personal injury claims in the circuit court is €60,000. Generally or usually the solicitors for the other side usually ignore your request to have the circuit court heard in unlimited jurisdiction, or in this case they sent a letter declining it. So then we must prepare a brief. So we put a file together, a copy of all the pleadings, relevant correspondence, and obviously the medical reports are very important here because that's the basis upon which the independent examiner from our doctor proves our client's injury or proves that the injuries have not improved. Once we have sent the brief to the barrister, and the brief includes all relevant court pleadings or court papers, correspondence, the barrister then drafts the motion. The motion then gets reviewed by ourselves, and the motion is an application to court to proceed in front of a judge to ask for their consent to have the action transferred, and then that then is supported by an affidavit by the client, and the client states out the history of the case, their current medical condition, why they say that the application should succeed and why it should be allowed transfer to the High Court. That motion is then stamped with court duty and issued out of the office and served on the other side, and we await for a court date. Once your date is upon us, which is in this case today, the barrister attends court on our behalf and makes the application in front of the judge, and then we must the other side are obviously allowed to attend and defend the action if they see fit, and make their case to the judge for having it to continue in the circuit court, and then the judge will make his or her decision on whether the application or the case can be transferred to the High Court. If our application is successful and the case is transferred to the High Court, we will then send the file to a senior counsel barrister. If we go to the High Court, we must brief a senior. The senior will then, as we have most of the pleadings are completed, we would ask the senior counsel to complete his or her advice on proofs, which is the checklist that we will need to prepare to have this case ready to be heard in the High Court. We also then make an application following on completion of all the advice and proofs for notice of trial, which puts us in the queue to have the case in the High Court hearing list. This process is obviously very important. This now allows the judge in the High Court to make an application, or to make an award if we're successful, of compensation of greater than €60,000. I would expect the case in the High Court will be heard from now probably 18 months to 24 months. I just found out from the barrister that our motion to have the case transferred to the High Court was actually granted today. It was an application in front of the County Registrar, and our barrister made the argument that our client's loss of earnings had increased to €47,000, and if you were to add in any compensation value on top of that, that it would be well into the High Court jurisdiction. The solicitor for our barrister for the defence was there and argued against it, but the County Registrar made an order in our favour, and the case will now be transferred to the High Court. We will now brief a senior counsel barrister, give them the file, and they will provide an advice and proofs on the best way to proceed to have the case heard and prepared in the High Court. So that's the end of vlog number 14. I hope I brought some value to you this week. Thank you very much for watching. We'll be back again next Wednesday. Have a great week.